different topics. Today, I'm going to be presenting on Probate 101. So what are some of the basic things that you need to know about probate? So in terms of the interaction that you're going to be required to have with the probate court, documents that need to be filed, and just generally speaking, when do you need to do probate and potentially how can it be avoided? So these are some of the topics that I'm going to spend all my time on today in addressing. I do want to preface this by saying there's a lot involved in probate in terms of if you wanted to know everything soup to nuts, that would be a much longer conversation than 30 minutes. So if anybody does have follow-up questions, please feel free to submit them at the end of the webinar. I'd be happy to answer them at that time. Also, I'll be providing my contact information on the slideshow that I have. I'm gonna share with you in just a moment. So please feel free to follow up after the presentation today if you do have any questions, because again, today the purpose is really just to give a general overview. So to that end, I will share my screen with you here with a PowerPoint presentation that I've prepared. So again, today is Probate 101. So what do you need to know first? And my apologies here. I'm just making sure I'm getting up to the correct screen. Here we go. So Probate 101. So first, what is probate? So just simply, probate is the court-assisted administration of an estate. So what does that mean in plain language? Essentially, you want to make sure your assets pass to the people you wanted to get them. So the probate court oversees that transition and make sure your assets get to where you wanted them to go. And also probate is going to provide that legal paper trail. It's going to show the actual transition of ownership of assets from you to your beneficiaries. The reason why this is so important is just because unlike things like deeds, wills aren't public record. They're not recorded and held by the town clerk. There's no central repository for everybody's wills. So they're private. So unless you submit them to this public kind of process, probate process, how is anybody supposed to know that your assets have transitioned to someone else? So again, the purpose of probate is to provide that legal paper trail showing that transition. An important thing also to know about probate, as I kind of just indicated there, probate is a public process. That means once documents are filed in the probate, so the will and other various documents that the court is going to require as part of the probate administration process, those documents are public record. People can walk in off the street to the probate court and say, I want a copy of the will of John Smith. And they may have to pay a fee for a copy, but they can get it. So for a lot of people, that's a really big concern, is they don't want to be having their affairs aired in public. And it's also a potential risk if you have are concerned about people, again, with nefarious intent, being able to figure out who your beneficiaries are and to some extent what they're getting, and then maybe kind of pursue your beneficiaries to try to relieve them of that inheritance. So it is something to be mindful of, that it is, again, if privacy is a really big concern for you, then probate avoidance is something you're definitely going to be interested in. And also then the second complaint, aside from it being a public process, the second biggest complaint that I get, or actually it's the number one complaint that I hear when I have a discussion about probate, is that it takes a really long time. So it's not as bad as some people think. So it's not a process that's going to take 10 years or so, or typically I should say it doesn't. But it does still take a while. So even there are various types of probate administration, and I'll walk through that again in a little bit of detail as we get into further into the presentation. But typically we're seeing probate processes take, again, on average for those shorter administrations, about 3 months, but for typical full administration, it's going to be at least 1 year or longer. So for a lot of folks, again, that can be a big deterrent. So one of the big takeaways that I want to leave people with too today is that there are ways to avoid probate. And again, I'll get into that a little bit more detail, but if you have concerns about the privacy aspect of probate, if you do have concerns about your assets after you pass being tied up in this court process for a while after you die, then you're going to really want to set an estate plan in place that achieves the result of probate avoidance. So, but again, I'll get into a little bit more detail on that as we go forward here. So what assets even pass through probate? When are you going to be required to do probate? And I find that it's important to know that what's going through probate is largely going to be determined by how you own your assets, not necessarily do you have a will or a trust. And again, that's part of it, but it's how you own your assets that's going to dictate what assets are going to need to pass through probate and which aren't. So it's only assets that are owned individually by you. So assets, not joint assets or assets that are passing via beneficiary designation or assets that are owned in trust. Those assets are not going to pass through probate. The assets that you own solely in your own name with nobody else, with no beneficiary designation, those are the assets that are going through probate. So you'll hear me maybe use the terms as we go through here: probate assets, non-probate assets. So again, probate assets are just those assets that are owned solely by you. And to kind of illustrate that point, I love this chart here just because it's a very clear representation of, again, kind of how you own your assets dictates what happens to those assets. So again, any assets that are owned jointly are not going to pass through probate. You'll see it's really a straight line that shows those assets pass down to the surviving co-owner. So if, for example, with married couples, a lot of assets tend to be held jointly. So the house, the cars, etc. So upon the passing of the first spouse, those assets typically are going to pass directly to the surviving spouse. And I should also point out too, joint ownership doesn't have to be between spouses. So if it's a parent naming a child as a joint owner, or again, just not a married couple, but partners want to add each other jointly on assets, you don't have to be married to own assets jointly. But again, to the extent that you do have jointly owned assets, those assets will pass directly to the surviving co-owner when you pass away. The second category of assets is assets passing via beneficiary designation. And some of the most common ones we see that fall into that category are going to be life insurance policies, retirement accounts, brokerage accounts, and other types of financial accounts, annuities. All of those assets, when you pass away, again, also just like jointly owned assets, will not need to go through probate because they're going to pass instead in accordance with the beneficiary designation that you've put on those accounts. So even if you have never done a will or any type of formal estate planning, if your assets are held primarily jointly or are passing through a beneficiary designation, you're not really going to have to go through probate. Or I should say your beneficiaries and your loved ones aren't going to have to go through probate when you pass because those assets pass outside of the probate process. To jump over to the fourth column here too, any assets that are owned in a trust, so it's called, in my box here, I call it a living trust. It's sometimes also known as a revocable trust. The names are interchangeable, but assets owned in trust will also avoid probate. So again, kind of the big takeaway here is that do I recommend estate planning for everybody? Yes. As you might imagine, I'm biased in that regard, but I think estate planning makes sense. But estate planning doesn't necessarily just mean documents. It's also structuring ownership of assets. So being very mindful of how you own your things, because again, probate can be avoided quite simply by just, again, if assets are being owned jointly, assets are passing through beneficiary designation, or if you already have a trust, or if you set up a trust, making sure those assets are owned in trust at your passing, again, is all three of those methods are going to ensure that your assets aren't going to need to pass through probate when you die. The third category that I had skipped over here is the individually owned. So again, those are the assets that are going to pass through probate. And unlike all the other columns, there's several boxes underneath this one because, as I kind of hinted at before, probate is a very long process. It has a lot of steps to it, which are, again, kind of evidenced by those boxes. And there's waiting periods in between steps too, which is part of the reason why the process takes as long as it does. But at the end of the day, you'll see the bottom box in the column is that your beneficiaries will receive your assets. But so the end result is the assets are going to get to exactly where you'd intended them to go. It's just they're going to need to, again, go through that process first before they get there. And I should back up too and say, so when we're thinking about preparing a will and you have a will, what does it say? Or what is the will kind of, what are your instructions in your will cover then? If they're not going to provide instructions for those beneficiary designated assets or joint assets, the purpose of the will is to provide instructions for where you want your probate assets to go. So if you're going through probate and you submit your will to the probate court, again, the will is only going to provide instructions for where your individually owned assets are going to go. So again, that's why it's so important to be mindful of how you own your things. So if you do want all of your assets passing to spouse first and to kids second, or again, just hypothetically, or to whomever you want to receive them, you need your will should say that, but then again, also your beneficiary designation should say that, or you should kind of be mindful of the assets that you may own jointly with other folks, because again, those beneficiary designated assets and joint assets aren't going to pass in accordance with the will, just because the will doesn't govern those assets. So, and I kind of, again, really covered this topic, but just to go through it again, at the risk of sounding repetitive, how do you avoid probate? Know how you own your things. For married couples, again, a lot of assets by default tend to be jointly owned. For a lot of assets, so the biggest one I think of is typically houses. Your real estate tends to be owned jointly. And then the next biggest assets tend to be the life insurance policies and the 401ks and the IRAs, which are set up to have beneficiary designations on them. So for a lot of the married couples that I meet with, upon the passing of the first spouse, there really is no probate, again, just because all of the assets are already passing outside of probate, simply by virtue of the way the assets are owned. Also, too, again, make sure you have those beneficiary designations updated. So if things change and after a spouse passes, you want to make sure now those are the primary beneficiaries passed away, or you decide you don't want to leave assets to the beneficiary you had previously named on your beneficiary designation form. Make sure you contact the bank or contact the financial institution where you have that account and fill out an updated beneficiary designation form with them. Also important to know too, if you have an account where you say, I'm not sure if I designated a beneficiary. I don't know if I ever filled out that form. I started my IRA 20 years ago and I can't recall. If you have an asset like a life insurance policy and IRA, like I said, those assets are set up by default to have a beneficiary designation. But if you never filled one out, or all of the beneficiaries that you've named, for example, on that account have passed away, there is a default beneficiary, and the default beneficiary is your probate estate. So if you pass away and you've never filled out that beneficiary designation form, those assets, instead of passing under a beneficiary designation, are now going to be required to go through probate. So again, apologies for being repetitive, but it is so important for that reason and for the others that I mentioned, to make sure those beneficiary designations reflect the current people that you actually want to receive those assets. Also, too, if you do have a trust, it's so important to make sure those assets are owned in trust, because a trust is a holding place for your assets. That's how it works. So it needs, in order for you to have assets avoid probate through your trust, you need to actually put those assets in trust. And this is a very common mistake that I see happen, is people come see us, we create these trusts, and then they forget to fund them. They forget to actually put the assets into them. So when they pass away, their assets are still required to go through probate because they never took that additional step of actually putting assets in putting assets in trust. And when I say funding a trust, from again, pretty much any asset that you have, with few exceptions, can go into the trust. So bank accounts and financial accounts, in order to transfer those assets into trust, you need to contact the banker, again, the financial institution where those accounts are, and tell them that you want those assets owned in trust, and fill out the paperwork and make sure that the trust is now named as the owner of those accounts. With things like real estate, you will need a deed that's going to reflect the transition of ownership from yourself and your spouse, for example, into your trust. And that deed is going to need to be recorded on the land records. And that's how you transfer real estate into the trust. So again, it's very important, if you have a trust, to make sure you take, after setting up the trust, you take that additional step of actually transferring ownership of your assets into the trust itself. Common probate myths. I almost every time I meet with clients for the first time and we start talking about probate, there's a lot of misconceptions out there, and a lot of it, I think, due to Hollywood. And for theatrical sake, there's a lot of situations that they pose that don't really happen in real life. So I find that's a source of a lot of these myths. But these are some of the ones that I come across pretty commonly, is that number one, if you have a will, you don't need probate. And again, to kind of circle back to that flow chart that I had up a few moments back, that's not what the will does. It's actually kind of the inverse result, that if you have a will, that's the instructions for what happens in probate, not keeping your stuff out of probate. It dictates what happens in probate. So again, just because you have a will doesn't mean no probate. Again, the will is the instructions for where your probate assets are going to go when you pass. Number two, if I have a trust, I avoid probate. So again, to kind of refer to the point I just made, this is kind of half true. If you have a trust, that's one of the primary benefits you're going to get from it, that you need to not only have the trust, you need to fund it. It is so important to put those assets in trust. So simply by creating a trust isn't going to avoid probate for your assets. Again, you have to take that additional step of funding the trust in order to get that result. The next one here is all of my assets are passing outside of probate. So I have all, for example, jointly owned assets and assets passing through beneficiary designation. So my loved ones never need to set foot inside a probate court. There's nothing that needs to be done. That may or may not be true. One is that there is a statutory requirement. So there's a law in Connecticut that says if you have a will, your executor is required to file that will with the probate court upon your passing. So that's a statutory requirement again there. And two, there's also this estate tax system in Connecticut that may impact, for tax purposes, the continued ownership of your assets by your beneficiaries. And really to kind of flesh out that question or that point a little bit more is what I'm referring to is real estate. So if you own your house, even again, if you own it jointly with your spouse or someone else, so it's for its own interest, so it's passing outside of probate. And maybe trust is not the great example. So I'll stick with the hypothetical of if you own your house jointly with your spouse, when you pass away, your ownership interest in that house isn't passing through probate. As I mentioned, ownership of that type of joint asset is going to pass automatically to your spouse. So your spouse will own the house without needing to go through probate to get ownership. That being said, Connecticut has an estate tax, and there's also a federal estate tax. And what the estate tax is it's a tax on certain estates that are valued at a certain threshold. So that threshold in Connecticut, in order for this Connecticut estate tax to apply, as of January of this year, that amount is $7.1 million. So I personally do not have an estate tax problem. I wish that I did. Most of my clients don't have estate tax problems. So you're saying, Allison, why are you telling us about this estate tax if it doesn't apply to us? The reasoning is because the way the estate tax system in Connecticut is set up is that the state doesn't know that you have less than $7 million. So they say, just in case you owe an estate tax, we put a lien on your real estate to make sure we're going to get paid. And this is, the state doesn't send you a notice in the mail, or I should say your beneficiaries a notice in the mail. They don't have to record anything on the land records. It's just something that happens automatically, is again, this kind of invisible lien is going to be placed on your real estate after you pass. And where it's going to impact your beneficiaries, or I should say the surviving co-owner of that real estate, is that if they down the road would like to sell the real estate and let's say move to Florida or downsize to a smaller house, or again, for any reason, sell the house, they're not going to be able to because there's this lien on the property. So before they're ever going to be able to transition ownership of that house to someone, they're going to need to go to the probate court and get that lien released. The way that's done is that they'll need to file an estate tax return with the probate court, which is again, evidence for the court to say, look, the estate is valued at less than $7 million. There is no estate tax due. Probate court, please release the lien on the real estate. And again, assuming the probate court agrees that everything you filed is correct, they say, okay, they issue a release of liens that gets recorded on the land records. And then again, you'll have, or your beneficiary or whoever's the sole owner of that property going forward is going to have clean title. So if they did want to therefore go and sell the property, now they're going to be able to do so. So again, kind of a very long-winded explanation just to say that even if 100% of your assets are passing outside of probate, there may still be some forms that need to be filed with the court just to clear up, again, ownership of those assets, or I should say, clear out that tax lien on real estate specifically. And I should also note too, when you file the estate tax return, that also triggers a probate fee that's going to be due to the court. So that not only are you getting a release of lien on the real estate, but then the probate court is going to assess a fee that's paid to the court based off of the overall value of the estate that you've reported on the estate tax return. So again, folks may already not be so happy about having to deal with the probate court when no assets are passing through probate. So unfortunately, it may seem like salt in the wound to some degree that not only do you have to file this return, but now you're also going to end up paying a fee to the probate court. Thankfully, the fee is not overly high. It's, I think, 1/3 of 1% of the overall gross estate. So the fee is fairly minimal. And actually, if you're so inclined, if you're a probate nerd like myself, you can go on to the Connecticut Probate Court website. And there's a probate fee calculator where you can put in the estimated value of the assets you think you're going to have, and the probate court will estimate the approximate fee that would be due. So if anyone's so inclined, ctprobate.gov, you can find that calculator and kind of do the math yourself. And last, another common myth, again, as I mentioned, kind of on my first slide, when I first started, some people think probate is just this endless process that takes years and years and years. And just is never ending. And I should say, do I have estates that have gone on for several years? Yes, but I think those are the exceptions, not the rule. The average probate when we are doing the full administration takes approximately 1 year from start to finish. And then for estates that are eligible for an abbreviated probate process, again, we're usually looking at a couple of months, around 3 months or so. And I apologize, I don't think I articulated the distinction between when you need a full administration, the full year-long administration, and when you're going to qualify for the shorter 3-month administration. Is that, again, it's going to be dependent upon the value of assets that you have passing through probate. Estates where the amount of probate assets are valued at $40,000 or less are going to be able to use this abbreviated, that 3-month probate administration, where essentially what happens is all the forms that need to be filed with the probate court are prepared and submitted all at once. And then it's just really waiting for the probate court to process those forms and issue you the documentation that you need. And then the full administration is, again, for those estates that are over that $40,000 threshold. So if the amount of assets you have passing through probate are over 40,000, you will have to do the full year-long probate administration. So if probate avoidance is your goal, which it's the goal for a lot of my clients, I would say yes, again, be very mindful of how you own your assets and try to structure things to avoid probate. But it's also not the end of the world if you have 1 or 2 smaller things that still have to go through probate. Because again, if it's just the car is the one thing that you never retitled or made a joint owner on, but it's only valued at $10,000 or $15,000. Yes, you have to do probate, but again, it's going to be that abbreviated probate administration, so you don't necessarily need the full year-long probate. So that is the end of my presentation for you all today. And actually, stop share there so I don't show you my email. If anybody has any questions, you can feel free to type them into the chat. So there is the chat feature down at the bottom of the screen. You can feel free to type a question in there, and I'm happy to answer, again, those questions today. Alternatively, you can also feel free to contact me either through phone or email with those questions. All my contact information, again, is on that slideshow. So if anybody did want a copy of that slideshow presentation, I'm happy to pass it along. Also, I am happy to, or I can let you know that all my contact information is on our website. So kkc-law.com. Please feel free to go there to get all my contact information and to see our prior webinars that we've had throughout this whole webinar series that we've been doing thus far. So let me see, and just looking at the chat, I don't see any questions coming in. Oh, and here we just have a couple that just got through here. So how much does a trust cost is the first question. So I hate to give a very lawyerly answer, but it depends. And the reason why I say depends is because we don't do, at least here at KKC, we don't do flat fees for documents. We do bill hourly. So the more complicated the trust, the more time we spend, the higher the cost. I would say on average, though, our typical revocable trust that's fairly straightforward is in the neighborhood of about $2,000 for us to prepare. But there may be some additional fees for, again, when it comes time to fund the trust. So for example, if you prepare that, we prepare the trust and then you also do the deed, to transfer your home into the trust, the town is going to charge a recording fee. So there may be some smaller fees that are associated with that as well. Oh, and another comment just saying that they would like a copy of the PowerPoint. So again, I'm more than happy to provide copies of the PowerPoint to all the attendees today. I'll make sure, I would say if you could send me an email through our website, and so that way we have your contact information, I'd be happy to pass along the PowerPoint to anyone who would like one. And I think that's all the questions that I see for today. So thank you all for joining me and kind of sitting through this Probate 101 seminar. And thank you if you've signed on and watched any of our prior webinars through this Wednesday webinar series that we've been doing. We are going to be taking a quick break with our webinars for the summer, but we're going to be starting them up again in the fall. So please keep an eye on our website or on our Facebook page, and we'll be providing information of when those webinars are going to be starting up again. So thank you all for coming today, and I wish you all a very happy remainder of your week and a good summer as well. Bye.